Good evening. A very warm welcome to Honorable Justice K.V. Viswanathan. We are extremely honored to have your presence with us today. I would like to invite Mr. Gaurav Banerjee on the stage to kindly introduce the judge. Thank you.
Good evening, everyone. As a member of the MCIA Council, it is my distinct honor and privilege to introduce Justice K.V. Viswanathan. There are some dry statistics in that he became a senior advocate in 2009, he was ASG in 2013-14, and I had the privilege of serving as his colleague, the 10th person directly elevated to the Supreme Court of India. But these are dry statistics. We have seen him, most of us have seen him grow from the time he came here to Delhi from Chennai, initially with CSV, KKV, and then, of course, on his own right. This is an arbitration scenario, and for those of you who do not know, I think he has appeared in almost every big arbitration matter in the Supreme Court. I can recall off the top of my head Cloro, Venture, Gemini Bay, iPay, I could go on, Amazon, Antrix Davis. So he's a domain expert in this field, but that would be underselling him. He's a domain expert in every field, and that's the truth of the matter. Just 2 points before he takes the stage. He recently gave a judgment, as you know, a dissent in Gayatri Balasamy. Of course, all of us have different views on that. And I wanted to mention two very interesting aspects of that judgment, not on the merits, but two aspects which stood out for me, and I think what really made him special, apart from the fact that he supported what we said, just leave that aside. Firstly, now the Supreme Court puts up arguments of counsel on their website. It is noted, it is archived, so you can check this. When the case was going on, he was completely unconvinced, or it seemed completely unconvinced of what this side was arguing. And if you go back to that video, you will see that there are a large number of very penetrating questions that he asked. We were put under the spotlight. Nakul was also there, so he will bear me out. So when the judgment was about to be delivered, we were pretty certain that he would possibly go with the majority. Imagine our surprise when this dissent came out. So the point is that we always say judges keep an open mind. But I can tell you that in this instance, indeed there was an open mind, and with the benefit of reflection, a judgment was delivered which was very different from what transpired in court. This is one fact which certainly struck me. And the second important aspect which struck me before I close and request him to address you all is that if you see his judgments, this is not arbitration related, he will always name the lawyer and he will always record the submissions of the lawyer. You cannot imagine how important this is for clients and for lawyers, howsoever junior they are or senior they are. It really, result doesn't matter, it really makes a difference when you know that somebody has considered your submissions, decided whichever way it is, but it's there in writing. One feels vindicated in a particular fashion when that happens. And I would urge others also to adopt this practice. With these few words, may I welcome Justice Viswanathan for his speech.
Thank you, Gaurav, for that generous introduction. I think no judgment can be written well unless the court is well assisted, and we had the best of assistance on both sides. My distinguished senior colleague in the court, former Judge of the Supreme Court of India, Justice Sikri, members of the MCIA Council, distinguished members of the audience, senior advocates, ladies and gentlemen, a very good evening to you. It's my singular privilege and a unique honor to be invited to deliver this keynote address at the concluding session of the India Arbitration Week on a topic of vital importance, marshalling India's core strengths in arbitration adjudication. For far too long, the narrative surrounding arbitration in India has been tinged with a degree of skepticism, often overshadowed by several negative perceptions. Indeed, the journey has had its challenges, but this narrative is undergoing a profound and irreversible transformation. India is not merely striving to catch up with established arbitration hubs. It is actively forging a path to lead, evolving into a formidable and globally respected center for dispute resolution. And I have tabulated reasons why I say that, and I try and justify that. This remarkable shift is not accidental. It is the culmination of deliberate legislative reforms, a strong and an independent judiciary, and the relentless dedication of a vibrant legal community. Today, I aim to demonstrate why India presents an increasingly compelling and indispensable proposition for both domestic and international arbitration. We are witnessing the dawn of a new era where India's unique advantages are converging to create an arbitration ecosystem that is efficient, equitable, inclusive, and globally competitive. What are the reasons and why do we say that? Our first and the strongest advantage is the availability of a deep and diverse pool of arbitration talent, the human capital advantage. Perhaps the most profound and undeniable advantage India possesses lies in its rich, diverse, and a highly skilled pool of legal professionals. We possess an unparalleled wealth of arbitration and arbitration lawyers. Our arbitration roster is significantly bolstered by the presence of retired judges of the Supreme Court and various high courts, bringing to the table decades of adjudicatory experience, a sound knowledge of law, and most importantly, an established reputation for fairness, impartiality, and procedural rigor. Whichever side of the bar you belong, whichever stakeholder you are in the arbitration, I think there is nothing more satisfying than having your case heard before a judicially trained mind who is seasoned as a judge with a judicial temperament, known for his knowledge of law, and of course, known for his integrity. I think that is the most significant assurance a stakeholder in an arbitration can have. Their involvement instills deep confidence in both domestic and international parties. But our talent pool extends beyond the judiciary. India offers an extraordinary breadth of sector-specific specialists, whether dealing with highly complex infrastructure projects, intricate energy contracts, or cutting-edge intellectual property issues. Our leading institutions have empaneled distinguished members of the bar, leading lights from the academia, renowned engineers, and forensic accountants. This ensures that the tribunals possess the precise technical understanding necessary to render commercially sensible and informed awards. Furthermore, India's arbitration bar is vibrant, globally exposed, and continuously evolving. A growing number of practitioners are exceedingly adept at navigating proceedings under all major institutional rules. The establishment of the arbitration bar of India is a watershed moment, fostering ethical practices and ensuring a robust pipeline of future arbitration talent and giving further impetus to the growth of arbitration in India. What's the second advantage? Unmatched cost competitiveness, democratizing access to efficient justice. It was 2010 at the, I don't want to name any venue, we had then paid a secretarial cost per day of £800 for the transcription and the day's charges with an ante room given to us. No doubt there were some cold sandwiches also. In an era where the escalating costs of international arbitration can often act as a significant barrier to justice, India presents a clear, compelling, and increasingly indispensable economic advantage without any compromise on quality or integrity of proceedings. Our arbitration ecosystem is demonstrably more affordable than established global hubs, a strategic differentiator that positions India uniquely. This affordability is not merely a budget alternative. It is a mechanism for democratizing access to justice, enabling mid-value disputes which could otherwise be excluded to be resolved efficiently and fairly. The impact of this cost-effectiveness extends beyond economic savings. It expands India's reach as an arbitration destination for parties from emerging markets globally who may find traditional high-cost hubs financially prohibitive. This strategic advantage makes India a preferred venue for a broad spectrum of commercial entities, including MSMEs and state-owned entities, allowing them to engage in high-quality dispute resolution without facing prohibitive expenses. By combining affordability with procedural reliability and internationally aligned standards, India offers a powerful and inclusive value proposition, attracting a wider array of domestic and international users and solidifying its position as a cost-effective, high-quality arbitration hub. But the third one is equally compelling, and I think the edge that India has there is unparalleled. A robust technological infrastructure and digital readiness. India has not merely adopted the digital revolution, it has embraced it with unparalleled enthusiasm, implementing it at a breathtaking scale across its dispute resolution mechanisms. This robust technological infrastructure and inherent digital readiness positions India as a pioneering digital-first seat of arbitration, a feature that is increasingly essential for cross-border disputes in today's interconnected global economy. The concept of seamless virtual hearings, hybrid proceedings, and secure digital case management is no longer aspirational in India. It is a standard everyday practice. Online witness testimony, remote cross-examination, and hybrid hearings are routinely conducted, significantly reducing scheduling delays, mitigating travel costs, and enhancing overall efficiency. Secure digital platforms for submission of pleadings, management of evidence, and issuance of procedural orders have become the norm, ensuring that Indian arbitration practices are fully aligned with and often exceed global standards. The unique strength of the Indian system lies in the judiciary's proactive embrace of technology. The Supreme Court, High Courts, and even trial courts are highly proficient with e-filing systems, digital records management, and virtual hearings. This familiarity translates seamlessly into arbitration proceedings, fostering an environment where technological integration is not merely tolerated, but actively encouraged and efficiently managed. India's digital arbitration ecosystem is underpinned by a solid statutory framework. The Arbitration Conciliation Act, alongside the Information Technology Act and the recently enacted Bharatiya Sakshi Adhinayam, collectively provide the legal backbone for online dispute resolution. This ensures the full enforceability and validity of digitally managed arbitral proceeding. Beyond the legal framework, India's arbitration infrastructure is world-class. Virtual platforms with features such as breakout rooms for private caucuses and sophisticated electronic case management systems have become standard, providing a smooth, efficient, and user-friendly experience for all participants. This end-to-end digital integration firmly established India not just as a physical seat of arbitration, but as a truly digital-first arbitration hub, offering unparalleled convenience and reliability. The next in line would be the strong common law heritage and the evolving pro-arbitration legal regime. India's deep-rooted common law heritage provides an inherently predictable, familiar, and reliable legal environment, offering significant comfort and assurance to international parties, particularly those from other common law jurisdictions. The foundational principles of natural justice, encompassing equal treatment of parties, procedural fairness, and unwavering adherence to due process, are not merely legal doctrines in India, they are deeply embedded and revered tenets of our adjudicatory culture, whether judicial or arbitral. This strong legal foundation has allowed arbitration to take root and evolve, fostering confidence among both domestic and international participants, and creating an environment of legal certainty and respect for arbitral autonomy. The familiarity of India's common law framework ensures that procedural aspects are well understood and predictable for international participants. Complementing this predictable legal environment is an actively evolving and increasingly pro-arbitration jurisprudence emanating from the higher courts of India. The Supreme Court and various high courts have, with increasing consistency and clarity, issued landmark rulings that strengthen party autonomy and deliberately minimize judicial intervention in arbitration proceedings. Multiple precedents have reiterated that arbitral tribunals are the primary authority to determine issues of arbitrability, emphasized limited judicial intervention at every stage in the process, clarified that contractual interpretation lies squarely within the arbitrator's domain, and underscored a high threshold for assisting the enforcement of foreign awards, to name a few. Taken together, these decisions firmly position India among pro-arbitration jurisdictions where arbitral autonomy is respected and judicial interference is consciously circumscribed. This dual advantage, the predictable legal environment stemming from our common law heritage and the evolving pro-arbitration jurisprudence, creates a robust foundation for domestic and international parties to confidently engage in arbitration in India. Building on this heritage, the Arbitration and Conciliation Amendment Act of 2015 marked an important milestone in India's arbitration landscape. It introduced crucial reforms aimed at enhancing efficiency and reducing judicial intervention. For instance, by providing a clear definition of court in the context of international commercial arbitration, the amendment shifted jurisdiction from district courts to high courts, centralizing oversight and strengthening consistency. It also empowered arbitral tribunals to grant interim measures with the force of a court order, thereby strengthening dispute resolution during proceedings. Courts were further directed to refer parties to arbitration if valid arbitration agreement existed, regardless of prior judicial rulings, the amendment to Section 8, to the contrary, thereby reinforcing the principle of party autonomy. Significantly, the 2015 amendments introduced strict timelines under Section 29A for the delivery of awards, 12 months extendable by 6 months with party consent, with provisions to reduce arbitrator fees in case of delays. The amendments further tightened public policy grounds for challenging international awards, expediting enforcement. The enactment of the Commercial Courts Act, both came into effect on the same day, if my memory serves me right, 23rd October 2015. Alongside these amendments, further reinforces the ecosystem by streamlining commercial dispute resolution and limiting unnecessary appeals. The evolution continued with the Arbitration and Conciliation Amendment Act of 2019, which sought to institutionalize arbitration further. By seeking to establish the Arbitration Council of India to grade institutions and arbitrators, the amendment aimed to enhance the quality and credibility of domestic arbitration. The 2019 amendments also introduced critical safeguards. These included confidentiality provisions under Section 42A and clear timelines for the completion of pleadings alongside immunity for arbitrators, further strengthening the trust in the process. At the same time, the 2019 Act recognized the complexity of international commercial arbitration and removed the 12-month deadline for such matters. The Arbitration and Conciliation Amendment Act of 2021 continued this trajectory of reform. To address concerns of fraud and corruption, it empowered courts to grant unconditional stays on the enforcement of arbitral awards, where the arbitration agreement, the contract or the award itself was tainted. The amendment also omitted the rigid 8th schedule introduced in 2019, which had prescribed qualifications for arbitrators and was seen as limiting India's ability to attract eminent foreign arbitrators. Building on these, the proposed Arbitration and Conciliation Amendment Bill 2024, following the recommendations of the Sri T.K. Viswanathan Committee, aims to further fortify institutional arbitration, to reduce court intervention, and ensure timelier resolutions. Key proposals include formally introducing the concept of the seat of arbitration, establishing a framework for emergency arbitrators as affirmed by the Supreme Court in Amazon versus Future Retail, and implementing faster timelines for deciding jurisdictional challenges. This continuous legislative evolution reflects India's ability to learn, adapt, and fine-tune its arbitration framework, ensuring it remains dynamic, globally aligned, and responsive to best practices. The practical impact of these reforms is evident. The 2015 amendments, whose applicability was decisively clarified in BCCI versus Kochi, were a game changer, coupled with the Commercial Courts Act, which streamlined court processes by creating commercial divisions and limiting the scope of appeals. These reforms ensure that arbitration operates in synergy with the courts rather than in friction, creating a robust, reliable framework for dispute resolution. Next is one of the most important assets that we possess and of which India can be very proud of, the soul of the system, inclusivity and integrity. Underpinning India's arbitration proposition are two fundamental pillars that form its very soul: inclusivity and integrity. India's pluralistic society and rich cultural tapestry are not challenges to be managed. They are strategic assets that enhance its appeal as a premier arbitration destination. This innate ability to accommodate a breathtaking diversity of perspectives is invaluable in resolving cross-border disputes, where understanding cultural nuance can be as important as understanding a legal nuance. As Justice Roma Paul, one of our very distinguished judges, observed, the Indian Constitution is akin to a salad bowl, preserving individual identity within a larger unity. This image captures India's ability to embrace diversity while maintaining coherence, an asset of real value in dispute resolution. Along with our other strengths, natural qualities of inclusivity and integrity are poised to make India an attractive seat for people from all parts of the world. Equally critical is integrity, the non-negotiable core of any effective arbitration framework. The Arbitration and Conciliation Act, particularly through its amendments to Section 12 and the explicit incorporation of IBA rules on conflict of interest in Schedule 7, rigorously safeguards the independence and impartiality of arbitrators. These provisions mandate comprehensive disclosures and disqualify arbitrators with conflicts, fostering profound trust and confidence in the fairness of proceedings. This unwavering commitment to ethical conduct is the glue that holds the arbitration ecosystem together, ensuring a safe and reliable environment for all participants. This codification, a statutory codification of IBA proposal under the then existing 2014 rules, I think they now have the 2024 rules, transformed what elsewhere remains soft law into binding statutory obligations. The Supreme Court in HRD Corporation versus Gale held that the presence of a red list ground would make an arbitrator de jure ineligible unless it comes under the waivable categories. The Indian approach reinforces that integrity and impartiality in arbitration are structural guarantees, not merely an option. Recently, in November 2024, a 5-judge bench of the Supreme Court in the Core 2 judgment rendered a landmark decision on the question of arbitrator independence and bias in lieu of unilateral appointment of arbitrators and unilaterally curated panel of arbitrators. The overarching view of the Constitution bench was that a level playing field was essential at all stages of arbitration. The court acknowledged that Arbitration Act mandates arbitral proceedings to be held under the ground norms of equality of parties, independence and impartiality of arbitral proceedings. Further, the court in the majority opinion relies on the constitutional norms of equality founded in Article 14 of the Constitution. The majority unequivocally opines that the independence and impartiality of arbitral proceedings and equality of parties are concomitant principles. Equal treatment of parties applies at all stages, including at the stage of appointment of arbitrators. India's growing strength in arbitrations sync propitiously with our nation's growing global influence. India's meteoric rise as a global economic and geopolitical power, coupled with its strategic geographical location, naturally positions it as a regional and increasingly global arbitration hub. Its leadership in influential international fora like G20 and BRICS further burnishes its credibility as a rules-based and reliable dispute resolution venue. The extensive global presence of the Indian diaspora also plays a significant role in strengthening trust in Indian institutions and can often influence seat selection in India. Furthermore, significant investments in smart cities, convention centers, and digital connectivity provide world-class facilities for both physical and virtual hearings, underscoring India's commitment to providing a state-of-the-art arbitration environment. The robust growth of arbitration is intrinsically tied to enhancing the ease of doing business, and its continued evolution promises to further streamline dispute resolution, foster investor confidence, and propel India's economic landscape forward with optimism and renewed dynamism. And it's a happy statistics from the Mumbai Center for International Arbitration. The 2024 annual report reveals a 48% increase in new cases, underscoring the growing trust and adoption of institutional arbitration in India. The remarkable growth reflects a journey of profound evolution, one underpinned by judicial excellence, a deep and diverse talent pool, unwavering integrity, compelling cost efficiency, seamless technological integration, and a trusted common law heritage. We began by saying that our journey had been difficult, but wherever we have erred or wherever there has been an aberration, quickly course corrected. And that itself is a strength. It is a strength to know one's weakness and to get over it. To appreciate our present and future, we must understand our past. India's arbitration journey is a long and instructive one, a testament to our national capacity to learn and course correct. The post-independence era saw significant developments in arbitration law, culminating in the Arbitration and Conciliation Act, the act that replaced the 1940 Act, the Protocol and Convention Act, and the Foreign Awards Recognition and Enforcement Act of 1961. By incorporating the ancestral model law, it marked India's decisive step towards aligning its arbitration framework with international standards. We have always learned from the mistakes, if any, and course corrected. Bhatia International, which expanded the scope of India's court intervention, represented one step in an evolving dialogue. This was thoroughly reconsidered and corrected in Balco, which rightly curtailed such intervention and affirmed the sanctity of the seat. The expansion of the public policy ground in ONGC versus saw pipes was a turning point where the judiciary stretched its scope of review under 34. This too was corrected by foresighted legislative interventions. Crucially, the progress is not the achievement of a single entity. It is the result of a remarkable synergy, a collective commitment where each organ of the state has put its best foot forward. The legislature has provided steadfast backing through progressive, thoughtful amendments responding to the needs of the time. The judiciary has played a transformative role through enlightened interpretation, rectifying past aberrations, and championing a philosophy of minimal interference and maximal support. The executive has facilitated the evolution by supporting the development of world-class infrastructure and enabling a conducive environment for both physical and digital arbitration. It is this harmonious convergence, this trinity of effort, that has strengthened every facet of arbitration from appointment to enforcement, realizing its critical importance for commerce and justice in our nation. The coming decade presents an unprecedented opportunity to consolidate these formidable advantages and cement India's position not just as a participant, but as a global leader in administration. By mainstreaming arbitration and continuously nurturing our institution and homegrown talent, we can create a system that is inclusive, efficient, and globally respected. The real, authentic Indian arbitrator, grounded in integrity and skilled in the art of adjudication, can now stand tall and proud on the world stage, ready to lead the next chapter of international dispute resolution. Thank you very much for your patience this evening.
Thank you, Honorable Justice Viswanathan, for the insightful words. I would like to now invite Nakul Diwan, MCI Council member, on the stage to to deliver the vote of thanks and the concluding remarks. Thank you.
Good evening, everybody. Now, I must tell you that I've been asked to play a role that I am not familiar with, because this is the first time that Madhukeshwar and Neeti have asked me to close the India ADR week. And I'm going to come to that in a way which is very different from what people normally do when they do closing speeches. So I've got about 7 or 8 minutes. That's the time that's been allocated to me. And I'm going to pick this up in what I would say 4 acts of a play. Act 1 is going to be what people normally do last, which I think should be done first, because I think it's important to thank a lot of people in this room for making it the India ADR week a huge success. First of all, Honorable Mr. Justice K.V. Viswanathan, thank you very much, sir, for agreeing to be the keynote speaker at our closing. We are very grateful that you've come, and I'm going to pick up on some parts of what you've said as I go along to Act 2, but Act 1 is not complete. Act 1 also requires me to thank the host committee. We've had an exceptionally good host committee comprising of Bhaskar Chandran, who's a GC of GMR, Mahesh Agarwal, a very well-renowned lawyer, Mohit Saraf, who's here in the room, Sanjeev Kapoor, again, who's here in the room, Sanjeev Gemawat, who's the GC of SR, and Shweta Bharti, a very well-known lawyer again. Thank you all for supporting the India ADR week. Again, this would not have happened but for all the support that you have given us. Most importantly, the India ADR week would never be successful but for everybody in the audience. Thank you, everybody. You've all been great. Great in Bangalore, great in Mumbai, and again, great in Delhi. So again, thank you very much for the support. Now, closing speeches, and I'm coming to Act 2. Closing speeches are typically those which bring curtains down. What you've heard Justice Viswanathan say is a reflection of why the curtains are just going up for arbitration in India. And he's spoken about certain aspects which I think are very relevant. And it's going to take me back, literally 14 years to the day, when on 16 September 2011, and I was significantly younger at that point of time, Fali Nariman, the legendary Fali Nariman, who all of us respect, and we've immensely respected, not just in India, but around the world, gave a speech at an LCIA India event. And he said there are 10 remedial measures which India needs to take if it wants to become a global destination for arbitration. And I picked up those earlier this morning just to get a sense of what he said. And you'd be surprised that there are at least 7 of those 10 where India has made huge strides in the last 14 years. And some of these have been touched upon by Justice Viswanathan today. The first, he said, parties must develop the spirit of arbitration and should learn to honor an arbitral award. And I can tell you statistically, that has certainly been done by parties in India. 2, he said the Supreme Court should be the exclusive forum for enforcing foreign arbitral awards in India. And while that's not happened in its entirety, as Justice Viswanathan mentioned, you now have the Commercial Courts Act, and enforcement of foreign awards goes to the Commercial Division of the High Court, and there has been a significant positive development insofar as enforcement of foreign awards are concerned. 3, he said parties should try to resolve their disputes by mediation. And you have a Mediation Act that's come into India. And again, I think India has taken huge strides because it's a signatory to the Singapore Convention on Mediation. 4, he said to discourage frivolous petitions in India, costs must not only be ordinary costs, but must be based on the basis of indemnity. And again, if you look at the amendments that have been made to the Arbitration Act, arbitrators have been empowered to grant costs. In also looking into the fact that if you have a recalcitrant party, arbitrators can certainly grant costs, and you see that now happening a lot more often compared to what it was earlier. 5, he said, establishment of an arbitration bar. Who would have thought in 2011 that India needed an arbitration bar? And you have the president of the arbitration bar in India in 2024. We set up the arbitration bar. It's got a lot of relevant people at the helm of affairs. And again, it's certainly helped take India into the global arbitration space. He also said, you have a necessity for good arbitrators. Justice Viswanathan made some very relevant points today about who is a good arbitrator. And all I can tell you is that I certainly endorse that view. The capacity and the pool of good arbitrators in India is exponential. Indian arbitrators now are routinely sought for and appointed not just in Indian-related matters, but in non-Indian related matters which are seated across the globe. Some of them are in this room. Mr. Nariman also, as a 7th point, said amendments were necessary in the arbitration bill. There was a 2003 bill at that point of time where he said, well, you should have less scrutiny of international commercial arbitration awards, and yes, that's the position that India is in today. He made an 8th point. He said Bhatia International needs to be reversed. Justice Viswanathan referred to that earlier. Bhatia International has not only been reversed, but I think the jurisprudence on Indian arbitration in the last 10 years has gone up exponentially. It is all pro-arbitration. He then made a point in relation to how foreign parties must look at excluding Part 1 of the arbitration. You have a lot of contracts which actually now make that provision, and I think Indian courts certainly respect such a contractual agreement between the parties. And the last point that he made was that a new law of arbitration or amendment of the existing one must incorporate principles like the one contained in French arbitration, characterizing the role of the court as one supporting the arbitral process. For a moment, let's leave the amendments or legislative amendments. most decisions that you now see of the Indian Supreme Court or of high courts categorically take the view that they are there to support arbitrations that are seated in India, or they're here to support arbitrations that are seated outside of India in whichever measure they take. And I am therefore very glad to say that most of the points that Mr. Nariman told the Indian arbitration community to adopt in 2011 have certainly been adopted. And that's one reason why in Act 2, I say the curtains are not coming down, they're actually going up. Well, now we come to Act 3. And the reason why Act 3 is important is because it's very important for all of us to understand that we work in a large ecosystem. The MCIA is just one part of that ecosystem. But it has made tremendous progress from the time it was set up 9 years ago. In 9 years, MCIA has reached a grand total of 201 cases. What is critical in these 201 cases is that it took 7 years to get to the first 100. And the reason for that is because when parties sign on to a particular clause, you don't have disputes which originate immediately. It takes 5 or 6 years for disputes to start. And in the last 14 months, we've hit another 100. I can only commend the Secretariat of the MCIA. Neeti is here, Madhukeshwar is here. They have worked tirelessly to take MCIA and put it on the GC map. Because that is the reason why 91% of MCIA's disputes have come from organic clauses as opposed to just having been referred to the institution. 15% of those have involved international parties. 5 different seats have been used for the purposes of administering arbitrations, therefore clearly suggestive of a way more pan-India reach and not just Mumbai. But coming to a point which Justice Viswanathan made on inclusivity, that's what the MCIA stands for. It doesn't matter where your arbitration is seated. MCIA will find you the best arbitrator. It has a very unique clause that the president of the MCIA is always chosen by the council. And that's a clause, if I again recollect correctly, I think Nick spoke about it earlier today, is a point which Fali Nariman had also pointed out too, suggesting that perhaps an institution should have a clause like that. And because of that clause, you have had varied appointments of exceptionally good arbitrators. Some of them have been retired judges, some of them have been counsel, and some of them have come from far and wide. And there are people who are so committed to doing what they do for the MCIA and for arbitration in India that they are willing to fly to the place of arbitration and stay at their own expense because they don't want parties to incur their costs. Of all of these appointments, and in going to ensure that we get the best people, 34% of our appointments have been women arbitrators. And again, that's a significant achievement by the MCIA because it now, in fact, matches what happens at the SIAC or whatever happens at the ICC. MCIA is literally looking at putting the Indian arbitration ecosystem and making it as good as any other institution would in the world. A couple of more statistics which I'm going to give you. 91% of the awards have been delivered in 18 months or less. Till date, not a single award has been set aside, which again is kudos to the arbitrators as well as to the judiciary where these awards have been challenged. And there have been no costs overrun, which means the parties have been able to finish their arbitration knowing fully well what their scale of costs is. But let's go a step further. We don't stop there because the MCIA decided that the way to really grow was to not just look at the people who were over the age of 60 or there. It set up the Young MCIA with the motto, catch them young, watch them grow. And it has used the Young MCIA to run tribunal secretary courses. It's entered into various MOUs. It's run courses on pleadings, on how to draft, And all of that in order to do one important thing, which is very necessary for arbitration in India: capacity building. Because as Justice Viswanathan said, you have a huge pool of talent. You have a lot of lawyers who come into the legal profession. And if you catch them and if you train them, you're only going to augment your legal system. And that is why I'm going to use this to literally close on Act 3 by telling you a little more about the India ADR week. It's an extremely important week for this country. And yes, it's a week which was conceptualized by the MCIA 3 years ago. But it's a week where the MCIA collaborates, because the MCIA believes that only if we stand united as a country, and we're a vast country, we've got various cities, we've got a lot of institutions, can we all succeed in making India the place to arbitrate in. So in this week, which is run through Bangalore, Mumbai, and Delhi, we've had 700 participants, 17 international jurisdictions represented, 24 sessions, 110 speakers, with no repeat speakers. And we have had senior members of the judiciary coming in and also supporting the endeavors that we have been making. But most importantly, in uniting everybody, we have had 30 arbitral institutions work hand in hand with us. 4 institutions from India. And that is what has led to the growth of the India ADR week. And that is the reason why we've managed an exceptionally successful week. And that's really where we are. So that's really Act 3 for us. And again, kudos to everybody at the MCIA for having united everybody together to really run a great ADR week. I now come to Act 4. And that's really my conclusion, and that shouldn't take more than a minute. All of this, in my view, is only reflective of what Justice Viswanathan just told us about arbitration in India. At the end of India ADR Week 2025, MCIA is not bringing the curtains down. It is, in fact, drawing them up and opening the door for the future growth of arbitration in India. The next India ADR Week, which will also be 10 years since the inception of the MCIA, is going to be held, and please mark your calendars, from the 7th to the 11th of September 2026. And it's going to be held in the same 3 cities that we have. And I'm sure over time, the India ADR Week may become an India ADR 2-week program when we go to Tier 2 cities. But for the moment, I think we're sticking to Bangalore, Mumbai, and Delhi. So please do mark your calendars from the 7th to the 11th of September 2026. In the end, and since I've thanked everybody, all I can now request you to do is something which you may consider a little mundane, but again, it's very important for us because we believe in feedback. The India ADR Week survey, where we have a knowledge partner in Nishit Desai Associates. There is a QR code which is there. Please log in and please tell us what you feel about the India ADR Week. And with that, curtains up. We've got a lot of work to do. So thank you very much for all the support that you've given us.